Good morning, everybody. Welcome to our monthly compliance webinar. Uh, Hopefully, all the technology works today since we're talking about AI. For those of you who don't know me, I'm Ann Lavelle, and I'm the compliance specialist here at CTR. We do these webinars once a month, but mark your calendars for, I believe it's May 7th. We're doing a live seminar again back down at PNC Park, which is just a beautiful, gorgeous venue. And you don't have to worry about the Pirates playing at the same time we're there. So you don't have to worry about them winning or losing, as the case may be. Although I have to say, I thoroughly enjoy watching their games just for the ambiance down there because it's just beautiful. So mark your calendars for that. Just a little housekeeping here. We do have Q&A open, and I'm happy to take questions about this topic or anything else really. As we go through, if we're running close on time, I'll save the questions to the end to be respectful of everybody's time. But I do try to answer everybody's questions, and I'll stay as long as we need. This is being recorded. So, if I have pearls of wisdom here that you just have to listen to again, it will be recorded and the slide deck is made available to everybody as well. So give us a little bit of time, but it is distributed and up on the website and all of that good stuff. I don't do that. The irony today is I'm talking about AI, and I am the person who breaks computers. So when they suggested this topic, I was like, oh no, not me, not AI. That's just asking for trouble. But in any event, I don't post anything on the website because I would break that too. So it does get done, but it just takes us just a little bit of time to get that up and running. Okay, I kind of already introduced myself. A lot of you know me. It's been a pleasure getting to know everybody. I worked for about a quarter of a century, which was long enough, as a partner in a very large firm downtown. And I was a partner in the labor and employment group. We did management only labor and employment, which meant we were always consistent. We were always on the side of the employer and handled what we used to call alphabet soup. So everything from the FLSA to the FMLA to the ADA, you name it. They've all got initials, not necessarily cool initials, but they do. And that's what I did. And I retired to spend some additional time with my family before they all flew the nest. And I really enjoyed the educational component for our clients when I was at the firm because an ounce of prevention is always worth a pound of cure and certainly is a lot cheaper than the cure that comes with attorneys. So it's my pleasure to be able to do this and be with you guys here. This is the commercial, and I probably don't ever do it justice in terms of what all CTR offers. But you can see everything there. And I obviously am part of the HR compliance and do help folks out from time to time who have sticky issues. So moving along here. Somebody asked if it's May 7th or May 15th. I don't have my calendar in front of me right this second for the seminar. I thought it was May 7th, but I've been known to be wrong. So we'll confirm that date because we did have to move it at one point because of the NFL draft. Apparently, they thought I couldn't compete with the NFL draft. Can you imagine that? I'm sure I would have drawn quite the crowd as opposed to the draft. In any event, but we'll confirm that because I have been known to be off of my dates. Break computers, talk about AI. Okay, somebody else said it's the 7th. I believe it's the 7th as well. But again, I make jokes that I walk into kitchens and I'm distracted by shiny objects and I don't know why I'm in the kitchen. So, in any event, usually what we do before we dive into today's topic is sometimes I talk about interesting legislative or court updates. And I also once a week put together what we post on social media, which is just like a 4 or 5 sentence little paragraph about some interesting stuff going on. And this is posted on the What's the Issue Wednesday, or it will be coming up. But I wanted to mention it here because I think it's a critical thing that a lot of employers do. And we have a large employer that was a Coca-Cola bottling company that has just been sued for it by the EEOC, so the Equal Employment Opportunity Commission. So before we get into AI, let me just mention this case that's going on. The bottling company had a women's retreat, essentially. So they had a one weekend event where the professional women in their organizations, and not necessarily their sort of frontline folks, but the folks who were in sort of the business capacity could go. It was a networking event. It was a weekend away. They didn't have to use PTO to do this weekend. And yeah, there were some perks to it, free hotel, free food, whatever. In any event, the men were not allowed to attend. It was a women's only event. The EEOC has sued, saying that's gender discrimination. And one, I point that out. So it's just at the beginning of the lawsuit. We don't have a decision on that yet, but I point it out because it shows where the EEOC stands right at the moment on things, and what some of their initiatives are. And two, having events like that or having a women's group or whatever group you might have is pretty common in a lot of workplaces. And it's been promoted historically to have these affinity groups or these little retreats or whatever you want to call them as a good idea to help folks succeed, or maybe you've got a special mentoring program, whatever it might be. Under the current EEOC, they're saying, hey, that's a problem. And if you're offering an event where there's networking opportunities, which theoretically could grow your career, then you need to make that available to everybody. And it's not fair to leave the guys out. And if it was the opposite, right? If we had a men's only retreat, a lot of people would be like, no, that's not right. So the women's retreat or the women's professional development weekend can't exist either. I mean, the obvious solution is we make it open to anybody. And since the Trump administration has been in place, and I stay apolitical on all things, I just reported. I don't, nobody asked my opinion on anything the administration is doing. We do know that affinity groups should be open to everybody, and there can be good reason for that. A lot of people know I have some adopted children from the foster care system. They don't look like me. They're different ethnicities and races. And I may have a real good reason why I want to join a particular affinity group, even though I happen to be Caucasian. And so there can be good reasons for people to want to join affinity groups that they don't necessarily look like. But certainly this case shows that the EEOC is willing to push this issue, and it's just something to be aware of. Okay, we're going to dive into AI now that we covered sort of this interesting case that's making a lot of news out there. So AI, and again, I'm the person who breaks computers. Let me summarize a couple of thoughts here. One, I think as an organization, you should embrace it. I think it's the wave of the future. I just think you need some guardrails around it, as you do with anything, right? So the reality here is they're out there, right? Folks are using this already within your organization, even if you haven't formally adopted a policy around it. They may or may not even know that they're using it, right? Sometimes you have folks who are maybe not as tech savvy, and they don't even realize that when they do a Google search that they get the AI summary up the top or whatever. And so to me, for companies, this is both your opportunity to embrace it, to use it to your benefit, but it's also a liability. And why is it your liability? There's a couple of issues going on here. One is this is like anything that your employees do. It's what we call an agent theory. They are your agent. So whether they're out there driving your van like a maniac and getting in an accident, or they're using AI in a method that you might not approve of or might be really off the wall, they are your liability. And so you have to recognize that all things that your employees do, they are your agent, and whatever they're doing, the liability transfers to the employer, whether it's AI or anything else. There's also huge issues surrounding copyright or privacy. And those issues play to the fact that the AI systems themselves are subject to tons of lawsuits, essentially alleging that the AI systems or metrics have inappropriately um, used copyrighted or trademark material to learn from. And if we use the fruit of that poison tree, we have the poison fruit, we're responsible, even though the AI program is the one who digested that copyrighted material in the first place. There's privacy issues as to what we put on that. And we're going to talk about all these in more depth. And we need to keep in mind AI is not human. And you're probably all like, wow, Ann, thanks for the news flash on that one. That's really important, though. There was just a case that that was denied review by the Supreme Court. So the decision stands where somebody created a work of art using AI and they wanted to copyright it. And the court said no. To be copyrightable, in other words, to be protected as intellectual property of some type, the core principle there is it has to be done by a human. So you're probably saying, well, I don't create art at work, so who cares? That's true for anything. So if you use AI to create something for your business, you have a copyright issue because, or a trademark, whatever intellectual property rights you want to talk about, because it's not created by a human. And that can be a problem depending on how you're using AI. If you're saying, hey, I've just used AI to create this wonderful thing, not necessarily an invention, but something, an advertisement, a slogan, whatever it is, you need to think about the fact that that was not created by a human, and you might not be able to protect that as intellectual property. In addition, an overall issue that I have, so from a defensive legal strategy, we always look at, well, what are the issues? And you can't get rid of all the issues. And you know you have to use this AI in various ways. Where's the safety net? So when we look at other things in employment law or any type of law, we say the safety net is insurance, right? It's some type of insurance product that gives us our safety net. So in employment law, that's usually employment practices liability insurance, EPLI. That is not necessarily going to cover this if we have a situation where we have a rogue employee who is out there using AI inappropriately. Will it even cover a situation where the AI unintentionally discriminates or intentionally, depending on how you look at things? And we'll talk more about that. That's untested waters right at the moment. And whether those policies, which were drafted pre AI, are going to cover that is a little bit of a murky area. And so we have opportunity, liability, and an uncertain safety net, which is a problem. And that's why we should be paying attention to this. Okay, so we know AI is in our workplace already, without a doubt. And if we look at what we call global knowledge workers, in other words, the people who are tech savvy, who are professionals, who are sort of doing tech stuff for a living, 3/4 of them are using it already. If we look at the average Joes, which I like to think I'm an average Joe, who's not necessarily tech savvy, we know about 33% of them are using it, not necessarily with our knowledge as an employer. We know that they're bringing their own AI tools to work. Now, this raises a whole bunch of issues, and I could spend the rest of the afternoon, not that anybody wants to hear this, talking about the issue of bring your own device to work. This just amplifies the issue because it's an issue across the board with respect to anything in employment or any type of litigation. So the first question is, what does your policy, because we should have a policy in our handbook or somewhere that encapsulates how we want to see IT used within our organization and some security and safety procedures, right? So whatever that may be, and it depends on your organization, some places they change passwords super frequently, in other places they're not really handling a lot of personally identifiable information, so maybe it's not as important or whatever. You should have a policy someplace, not just with respect to AI, but just in general that talks about your IT systems are for business use. It's okay, a little incidental personal use. I've never seen a company be able to eliminate that completely. I've seen some try. It just doesn't really, from a practical standpoint, work. But that however it's being used, it should be used appropriately, right? Not to harass, not to discriminate, not to be a jerk with. And then, of course, you ought to address the BYOD issue, which is not nearly as much fun as the BYOB issue. The BYOD is, what about your own device? So I'll bet everybody on this webinar, and we've got quite a lot of folks, has their own cell phone that they do business on. And they probably have their email on there, and they probably text message about work and whatever. If you get into litigation, and again, this becomes a huge issue, not just with AI, but across the board, the information on that phone is discoverable. And so then you have a problem. Anne Lavelle was texting whatever about whatever topic that is being litigated for the employer. And now we need her phone because the other side wants to do a forensic analysis and see the data on that phone. So depending on your level within the organization, and depending on how sensitive the information is, that BYOD policy becomes very, very critical as to how you allow employees to bring their own technology into the workplace or use it for work-related things. Do you provide them with their own cell phone? Maybe you don't care because they only text once in a blue moon and you're a small company. Maybe they're in a sensitive position and they're texting quite frequently and emailing, calling, and whatever, and you really want control of that device. Because particularly if you get sued, you want to be able to control that, have that readily available, and be able to conduct your own forensic investigation if there are issues. So AI just amplifies the idea that employees are bringing their own technology, their own devices to work, and they're using it for AI. And so we should be thoughtful about how we allow people to bring their own devices and whether we put into their policy, hey, if we get sued, we're not going to take your personal phone and analyze it. Employees really don't appreciate that. I can tell you firsthand. Not that my phone was taken, but as a defense attorney, we would start collecting goodies like that and having them looked at by computer forensic type folks who would look at what was on there, what kind of data, whether it had been tampered with, that sort of things. All right, so I'll get off my little spiel about BYOD, but it's an important issue outside of AI. Why is this happening? Well, everybody likes something that's fast and easy and free, and some of it's free, some of it's not. And of course, it's everywhere. We have to embrace it. And a lot of employees may not even realize they're using it, especially if they're not tech savvy. Common examples here, really anytime you run a search, you're probably getting AI as sort of a summary at the top. Yeah, this is kind of referred to as shadow AI when the company doesn't even know that this is going on, or it's going on without any type of governance around it. So putting some type of governance is the first key here. If you don't have any governance, I think you automatically have a liability issue because you haven't even been thoughtful enough to put some guardrails around here, right? And it's no surprise, no mystery that the employees are using it. If we don't put some guardrails into our handbook or somewhere, policy, whatever, and the plaintiff, whoever is complaining about our use of AI, says, well, what was your policy on it? That should be Exhibit A, right? And you don't have it. You sort of might as well raise the white flag in that litigation. And we'll talk about the types of cases you can get involved in here, types of litigation. But you need to have some type of policy. This shouldn't be a shadow AI system within your organization. So what do we want to address in our policies? Well, confidentiality, right? We no different than a personnel file or an electronic personnel file. We should be thoughtful about what in the world we're uploading onto the system. Who has access to it, right? Is there a privacy issue? Is there a discrimination issue? That's probably the thing everybody hears about with respect to AI, and we will talk about that, but I think that's probably the most well-known issue out there. Okay, so somebody asked a question. Because this is a great question. They said, with the BYOD, would the entire device be a part of Discovery or just an app that is used for communicating, such as GroupMe or Google Voice? So the way this works in actual litigation, right, is company A gets sued for whatever, pick your poison. And as part of that, once you have a lawsuit, there's what's called a discovery phase. If you've been through litigation, you know you'll be served with interrogatories, requests for depositions, requests for production of documents. And documents just doesn't mean just paper, right? That's where we get the idea that we are going to collect devices. And so what happens is, as the attorney, we talk to whoever's our contact at the employer, and we say, well, hey, they're asking for any messages, any communications regarding topic XYZ. Where might they be? And they'll say, well, it's on our computer system, it's on the cell phone that the VP uses for whatever, and it's on the CFO's phone and whoever. At that point, we don't just hand over a phone to the other side, but we are cautious. We have an ethical responsibility as counsel to see what's on there, to make sure it hasn't been tampered with. And because sometimes your own employees will do stuff that you're not going to appreciate. And they'll think, oh, I don't like this email or this text message, delete, delete, delete. And they shouldn't. They think they're being helpful. It's not necessarily because they're malicious. And so guess who gets the phone first? Your defense counsel, right? And then we look at it, and we've probably retained a forensic type of IT group to look at the phone, to print out what we need, to make sure that that's the only place where the information is. So it's not necessarily just an app. We're often looking at the actual content of the entire phone, particularly if we have an employee that we're concerned about, who is part of our defense, and we may or may not feel confident about him or her. And we're looking at what's on there. So to answer the question, it's not necessarily just the app like GroupMe or Google Voice. It oftentimes is the entire phone, because we have a due diligence obligation as counsel and you as the defendant to make sure we've captured everything and turn it over. Then the second issue you can get is we turn it over and we certify this is everything. We've turned it all over. Think of the Epstein files. We've turned it all over, and somebody questions it and says, I don't think so. In fact, sometimes they wave a little red flag. We have this text message and you didn't produce it. So where in the world is it? And then as defense counsel, we're going, ooh, where did they get that from? Because we thought we had it all. And then the other side might ask the court to get the actual technology so that they can conduct their own forensic investigation. It depends on the level of the case and how broad it is, how much technology might get involved. But what it's called e-discovery, electronic discovery, is super expensive to engage in. And it is time consuming because you've got experts involved who are outside the legal field. I don't know how to do a forensic analysis of a cell phone, trust me. And it just takes a lot of time. So I hope that answers your question, because that's a great one and it extends beyond AI. It's really critical for any company of any size to understand that that's a possibility and to think about how they would handle that if that occurs. All right, jumping back in here. We've got the infringement, privacy, ownership type issues that we need to address. Documentation quality. I'm sure anybody who's listened to the news has heard of the AI cases where AI makes up stuff, right? I don't know how it gets so creative, but it does. It's done everything from making up court cases to past history that doesn't exist to whatever. And of course, decision-making accountability. AI should not be making significant decisions for us. If it wants to make the decision of how it puts, salutation on an email, who cares? But if we're talking discipline termination, if we're talking about how we're going to do the next step in something major for the company, it shouldn't be making those types of decisions without human oversight. Okay, obviously, AI does not erase employer responsibility, it just adds to it. And so with AI, you still need to comply with all the employment laws. Not surprising, right? I don't think anybody sitting on this webinar is shocked that AI somehow doesn't have to or still has to comply with these laws. I want to point out something. Again, this crosses borders beyond AI, but I think it's important since we're talking about it. Biometric laws, have you looked at them? You're probably all saying, gosh, that sounds really exciting, but no, I haven't looked at them. So biometric laws are state-based right at the moment. There's really not a federal umbrella law that covers everybody everywhere. But if we look at states like Illinois and California and a couple of others, they have really aggressive biometric laws. And you're probably like, I don't know, what are you talking about? So it's capturing any type of data, right? Facial recognition, fingerprints. Sometimes it goes beyond that and captures any sort of personal information, private information, in theory, your email address, whatever. And usually the laws are triggered by having a certain amount of that information. So if I just have one fingerprint, nobody's going to care. But if I have 1,000, maybe they do. Or maybe if I have 1,000 email addresses or 1,000 touches somewhere. And you're saying, well, I'm not in California. I don't have 1,000 of anything anywhere over there. What some of those states are claiming is that if you have a website, you do, because you could have that many people look at your website, and that could be an issue. So this is not a webinar on biometric data and privacy claims, but be aware that that is out there. And AI sometimes uses facial metrics or other things for decision making or incorporates them into decision making. Be aware that if you are in states with biometric data laws, that's certainly going to come into play. And of course, documentation. One of the biggest issues, we all know about the discrimination. That's not news to anybody. But the record keeping and the documentation. So just because I have AI select whatever, I'm going to have them select the 10% for layoff in my company that I need to downsize. Can we defend that situation? Has anybody looked at the documentation gaps? What did AI use to make that decision? And how are we defending it? Again, I always come at it from the standpoint of how do I defend it and where's the safety net? Not sure we have a safety net for AI right at the moment because it's still in its infancy, and insurers have not caught up with whether or not and what type of claims they may or may not cover. But we need to look at, do we have all our I's dotted and all our T's crossed with respect to any decision that we're allowing AI to make or any input into decisions that it's making? So I've seen online, and all of you are on the ground on this, so I'm sure you've seen it too. There's lots of classes being offered on get your certificate in HR AI. That's great, right? We should be embracing this, but be aware these are some of the ways AI is being used, and that's okay. But if you tell AI to generate an employment policy, maybe subject to the Pregnant Workers Fairness Act, maybe that sounds great and it spits out something at you, but maybe it hasn't thought about state law that's more generous. And so you need to be aware of that. Agency filings. So a lot of you, if you're a federal subcontractor or a federal contractor, any type of law firm, and they've had this issue more than once, that's making some type of filing where you're doing it either under penalty of perjury or under oath somehow, whatever the criteria might be for that filing, the fact that AI did it and AI imagined something within that filing that doesn't actually exist puts the liability on the person who said, yes, I'm filing this under penalty of perjury or under oath or whatever it might be. It's a huge problem. And there's been several law firms that have received what we call Rule 11 sanctions, which is really something you never, ever, ever want for doing that, for making filings without checking them and then signing off on it as counsel of record. Same concept with federal contractors and everything else that might have an agency filing, banking, whatever. The person who's signing off on it still has an obligation, a legal obligation to make sure that data is right. Okay, so some quick examples here, because I know we're running, we're already halfway through here. You know, a recruiter pastes resumes into an AI tool and says which candidates are best. Whatever AI picks, you have to be able to defend AI's decision. You know, AI made that decision for you. And of course, there's always the issue as to whether there's an inherent bias in AI, because AI learns from everything, the good, the bad, and the ugly of our society and our culture. And so how do we know whether that AI program has some sort of inherent bias? That's really, really tough. If we were still under President Biden's administration, he was very concerned about that and had a lot of guidance and rules around using AI in the employment context and saying, hey, you better ensure there's no bias, and whatever computer program, whatever AI program you're using, better have ensured that as well. President Trump, and again, I stay apolitical here, embraces AI a lot more and is like, hey, we shouldn't be so worried about that. We should be embracing it, make our country stronger, better, faster, whatever. And so that's not really as much of a priority for him. So maybe from a federal level, we don't have as much of a concern, but from a state level, we sure do, because a lot of states have their own rules about this. And so you should be aware that that is floating around out there, that although President Trump may have pulled back President Biden's concerns and guidance regarding AI in the workplace, the states have not, particularly if you're in a blue state. Again, performance reviews, that's fine. You can use that to write a performance review, but somebody needs to be overseeing that, right? And looking at whether it's correct and whether it makes sense and whether they can defend that. I'm going to throw out a little curveball here. If a manager is using AI, let's say you have a supervisor, relatively low supervisor, who, for those of you who have heard me talk before, I always worry about assistant managers, frontline supervisors, as to whether they're truly exempt under the FLSA. Many of them are not. But oftentimes, employers hang their hat on the fact that the manager has sufficient input and independent judgment and discretion into the employees underneath them, performance reviews, hiring, firing decisions, whatever. If we all of a sudden have AI doing this, what has happened to that manager's independent discretion and judgment? Do we still have sufficient judgment if AI is writing up the performance evaluations and the discipline and whatever else AI is writing up, to say that manager is still exempt if we have made them exempt under the FLSA, whenever those managers tend to be questionable to begin with? So I'm throwing that out as a curveball because this isn't an FLSA type of webinar, but that would be a big concern of mine if I had folks who were on the border of being exempt, and all of a sudden I have AI doing a lot of their duties. All of a sudden they look a lot less exempt to me. They look like they're hitting a button on a computer to do the review or whatever, discipline, whatever it might be. And they don't have that independent discretion and judgment that we're hanging our hat on to make them exempt. All right, I have another question here. If I can get my little mouse over to the Q&A. Let me see if I can answer this real quick. Okay. With looking at resumes, are you able to have AI highlight skills of candidates and then pick the best interview and hire versus asking it to pick the best candidate? Sure. That is one way to look at it. And actually, you could have AI pick the best candidate, but then I think you have to be able to justify that. And the next question is about prompts. Is there a way to write an AI prompt that shows was used for informational purposes? I can talk, and not decisions. Um, I don't even have an issue with AI making some decisions, but I think we have to say, so one of the things we're seeing in litigation right now is during that discovery phase. Remember, we talked about handing over your phone during the discovery phase. The other thing that these companies who, it's the big dogs in town who are getting the lawsuits right at the moment about how AI is being used in HR or any context. And one of the discovery questions that comes up over and over is, what prompts did you use? So, do you remember what prompts you used? There's probably a computer record of this somewhere. And again, I'm not a computer forensic type of person, but that's what they're looking for. So they're looking for, did you enter an appropriate prompt? So to go to the person's question about the skills. So I need, for skills, I need a chef, and I need a dessert chef. I don't just need somebody who can cook steaks. And so I put in, and of course I'm making all this up, right? I want candidates who have dessert experience, right? And maybe in particular, I want candidates who have French dessert experience because I'm opening up a French restaurant. I don't see any issue with putting those as prompts in to say, screen these resumes and tell me who has French dessert experience, especially if on our job announcement, we have said we are seeking a candidate for a senior chef position who has at least 2 years of experience in whipping up whatever French creations it is that we want. The person's on notice to put it in their resume. We have looked for it. And then the one person here in the questions is saying, I'm going to make the decision from there. That gives you extra security, I think, to say, hey, I was just looking for a skill. And then I made the decisions from there. I think you could even have AI rank the resumes. I think you just have to be able to look at it and say, can I justify this? Did I oversee it in some reasonable way? AI handed me the 5 top resumes for French dessert chefs. Makes me want to go have dessert right now. And I looked at it and I disagreed with AI because I actually thought candidate number 3, because they went to school XYZ, was the best candidate. And so in any event, there is no guarantee that whatever AI prompt you put in will be acceptable to the plaintiff's bar. This is always a subject of litigation, right? It's the same as if you were sitting here asking me questions during an interview. The other side will always challenge it. So there is no, well, if you put this AI prompt in, you're guaranteed no lawsuit. No, it's, did we use some reasonable thoughtfulness and can we defend it? It's never a question of, can we avoid a lawsuit? You can't. They will happen to everybody. But can we defend the prompt we put in? Would we be proud of that prompt if it was in the newspaper? And that's the same as, would we be proud of the interview question if it was in the newspaper? Okay, hopefully that helps a little bit. And again, I think you can have AI put input into decisions, make some decisions, but it needs human oversight to make sure we haven't done something squirrely or AI hasn't done something squirrely. Okay. Moving along here. So, what you're looking for, that's a problem, and I think a lot of us know this, and we've kind of touched on this already. We can't screen out certain groups, and that is the concern about inherent bias that we might not even see or know about in the AI algorithms. President Biden, again, was very concerned about this. President Trump, not as much. But the states, particularly blue states, still are concerned about this, and they look at this differently than the feds do. Is the process job related? Is what we're asking and what the prompts we're putting in, is it consistent with business business necessity. If I want a French chef and I'm putting in there they need to make a good mousse, I don't even know if that's a French dessert, then yeah, we can justify that, right? If we put in there instead, we want the person to have lived in France for 5 years, would we potentially be screening out certain candidates or favoring folks who are French citizenship, French nationality over other nationalities? Maybe that gets a little bit more squirrely as to whether or not that's an appropriate prompt. Um, Adverse impact. So if you were in some of our prior webinars, you know the EEOC is moving away from the concept of adverse impact. Adverse impact is not direct discrimination. It's not me saying, hey, Anne, I don't like you and I'm not going to hire you because you're over 40. I know that comes as a shock to everybody that I'm over 40. That's direct discrimination. But if I have a policy that statistically discriminates, even though it's facially neutral, that's sort of the adverse impact. And that is AI. So the EEOC may have moved away from that concept of adverse impact. That's not the type of lawsuits they want at the moment. Keep in mind that can change in a couple of years with a new administration. So still be thoughtful of that. But the states, particularly the blue states, still have that concept that I can have a facially neutral prompt put into AI, but it adversely selects, has an adverse impact on minorities or a certain gender or nationality or whatever it might be. Can we explain how the tool influences our decisions, right? There's a big difference between I just let AI go for it and I let AI select the top 10 resumes and then I carefully reviewed. And I also maybe randomly reviewed a couple other resumes just to make sure we weren't missing the boat with AI and our prompts. Does the EPLI cover this use? The jury is out on that one as to whether they would, if you get sued for discrimination because of AI, how will EPLI look at that? And so that's a concern. A lot of AI with respect to disability discrimination. So AI, and this goes for any computer test, any computer program that you may use in your workplace that might rely on speech or facial recognition or timed tests or timed activities of some sort, can disadvantage the folks who are disabled, right? If I am dyslexic and that's a disability, I think that would not be contested. And I need to use talk to text, which is slower than the average person can type, or a professional could type, maybe. And that makes me slower at doing a task. Do we need to accommodate that person who's dyslexic, who's using talk to text? The answer is probably yes, right? First, we have to say, okay, you don't have to type. We'll get you the talk to text software. If it's not already on our computers, almost all computers have it. And we will make those accommodations and we may change the rate of production because we recognize that talk to text is slower. And some of you right now are hitting your heads off the wall and saying, great, I have to spend money on a computer program. Maybe it's somebody who's blind. And so I have to have a Braille reader on the computer for them to do it. A Braille reader is something that goes over the screen and essentially changes as the text on the screen changes. It's really slick. I have to pay for that. And maybe that's, I don't know how much this costs. Let's say it costs $1,000. Yeah, because otherwise the EEOC will say you wouldn't spend $1,000 to help a person, but you spent $2,000 on the company picnic and the employee yearly gifts and whatever else it is. It's really tough to argue that some type of technology modification is not reasonable, whether we're talking in the AI world or just in the general world for somebody who's disabled. So be aware of that out there. Okay, one of the unfortunate things that happens with AI and other things too is sort of a privacy issue. And that is, maybe I want to see what AI's opinion is on who should get promoted. So I'm going to put Anne's records in there, her performance reviews. I'm going to put Joe's. I'm going to put whoever. And when I upload those, a lot of AI systems maintain those records in some form and store them to train on them. And so not only do I have the issue as to how AI is making that decision and whether there's been sufficient human oversight and appropriate prompts for this, but I have the issue of whether or not I've just let Anne Lavelle's personally identifiable information run amok over the internet or the companies, right? Tell me what the sales projections should be based on the prior history. And maybe we consider that confidential business information and we've just uploaded it someplace. So we certainly want to prohibit that in our policies of watching what can be uploaded to AI or used by AI. You can see the types of categories that you'd want to be very cautious about, or you'd want to redact the information before you let AI have it, or any computer system for that matter have it that you're looking at or sharing information with. And some of this becomes quite concerning. Social Security numbers, there's lots of laws about how you use those. Employee medical information, generally not HIPAA, I'll just hit on that again, but under the Americans with Disabilities Act, prohibits use of that in certain ways. So you need to be thoughtful about the information and what you're allowing folks to use when they're using AI or any computer system. All right, so kind of have hit on this, but it's worth re-going over. AI usage policy, you should have something, you should have a technology policy of some sort. That's the starting point, really. That should be in place already. If you don't, now's a wonderful time to put one in place. It should have an AI component. If you already have the IT type of policy, then you add the AI component to it. Some training, particularly with respect to the employees that you think are most likely to do this or most likely to do it wrong. Some training somewhere, some data protection rules that what they should or shouldn't. Because when you have the employee who uploads everybody's personnel file to some computer system, AI or otherwise, and you want to fire them, you want to be able to show they broke a rule and the rule was written and they acknowledged it and they had training on it. That's true for all discipline and termination. And give them guidance, right? Yeah. It's fair to our employees. We want to be ethical that we're going to give them some guidance as to how they should be using this. And we want to be cognizant of the copyright type of issues, both that we're not using copyrighted material somehow inappropriately. And also, if we have AI create something, that we think about how we want to protect that information since it's not created by a human and isn't necessarily copyrightable. All right, some local regulations. You can see the states are having a good time with this. With respect to AI, not surprisingly. So in employment law, we used to have a saying that where California goes, the rest of the nation follows with respect to employment or other similar laws. California has really stiff biometric laws to begin with. They've got some AI employment regulations, and you all may be saying, hey, they're 3 hours behind us and I'm not in California. It's worth keeping an eye on because what they do is often mimicked by other states, particularly the blue ones. And again, that's not to be political. That's just sort of the way it is. They follow that lead. And knowing that California is particularly strict on this should be a heads up for us to get our house in order before Pennsylvania or whoever decides that they want to have their own AI rules that are equally as stringent. So do we know who's using the AI? And could we know? We should know who has access to AI and who's doing that in our workplace. How do we let our managers use it? Are we risking them no longer being FLSA exempt by allowing them to use it? Do we need to rethink that? Do we have third parties using it to help us recruit or help us to rank our candidates? We should be looking at that. What about the confidentiality aspect? Have we looked at it for the adverse impact type of statistic? And again, this is sort of where a random overcheck comes into play. AI picked these 10 resumes, but did we sort of look to see if we were concerned about anywhere else? Do we have a policy training What about an approval process? If somebody says, I want to use this new AI tool and I think it would be great for blah, blah, blah. Who owns it internally, right? Somebody should own responsibility for this. Probably nobody wants to own it, but really somebody should. And how are we protecting the information that we as a company generate from AI? And I mean intellectual property or the confidentiality of that information somehow, since it's not human generated. All right, create, train, restrict. That doesn't mean people won't do it, but now we have a rule that says if you do it, there's huge consequences, oversight. And again, monitor those regulations like those coming out of California so that we know what's going on. And again, how are we using it? Do we have human review and accountability? Where's the data coming from? Because we don't want to get sued for using somebody else's confidential information that somehow is out there, or copyrightable information that AI used to help us with something else. If we ask them to develop a new process for our assembly line and AI uses a trademarked or copyrighted process and we emulate it, now we have a problem because we have violated whatever intellectual property rights AI violated. We're still responsible, even though AI is the one who studied the information, trained on it, came up with the idea, and gave it to us. We're still responsible if AI inappropriately took that information from somewhere else and we're now using it. All right. So just remember, manage the AI systems and the employee use. But I do think you need to embrace it. It's here. It's like when the web, I'm old enough to remember when the web came out. And employers like, I don't know what to do with this. You embrace it, but you put some guardrails up, and that's important. All right, let me make sure we don't have any last minute questions here. And otherwise, we'll be back in April. These compliance seminars are usually the second Thursday of every month, and then May 7th for the seminar. By the way, at the seminar, we're starting something new. We're going to have like a food drive to support some community partners. So that should be hopefully a good thing as well. In addition to getting together at a beautiful venue. Okay, I don't see any other questions. Thanks everybody for attending. Stay warm out there today. Hopefully we get better weather soon. Take care.